Okay, good morning everyone on this sunny or otherwise, depending where you are, Wednesday morning. This is our new time of 8 o'clock, much to Mr. Sharp's horror. And this morning we are with Jon, who's talking to us about project security. Now, as always, if you could pop your questions into the Q&A facility in the bottom toolbar, and then Jon will address these at the end of his presentation and answer as many questions and queries as possible for you. Again, as usual, if any of you want to contact Jon with specific issues, his contact details are within the presentation slideshow. So without any further ado, Jon, I shall hand over to you. Take it away, Mr. Sharp.
Oh, thank you very much, Julie. Good morning, ladies and gentlemen. I trust you're all well. I'm not quite sure I like this new start time of 8 o'clock, but there we are. Project security. Really, contractual relationships and how to get paid as a result of them is really what this talks about. So without further ado, there's me. All the details are on the firm's website, so I think the less said about him, the better. In terms of what we're going to have a look at today is the need for security in construction contracts, design liabilities, standard form contracts, key provisions and mechanisms. We'll look at some common problems, some issues with third-party rights, collateral warranties, and then bonds. The need for security in construction projects. Shortly, a contract as a contract, in essence, sets out the terms of the business relationship between two parties. It carries with it burdens, so obligations that a contracting party has to carry out, but, and this is the good part, it will also contain provisions as to how you get paid for your work. So, who is it that can take action in relation to any contract? And shortly, it is only the parties to the contract. It is not Joe Bloggs who lives 4 streets down. He has not got any privity. And the privity rule in contract law is fundamental and is explained at the House of Lords in Dunlop Pneumatic Tyres and Selfridge & Co. Limited. It is a fundamental principle of English law. It has been established for hundreds of years, and the principle is that only a party that is a contract to it, who is a party to a contract, can sue on it. Now, this doctrine obviously protects parties against claims from strangers in most circumstances, but there are commonly times when the parties to a contract expressly agree that some other entity is to benefit. That's not unusual. For example, under the JCT D&B 2016, it is stated that other than such rights of any purchasers, tenants and or funder as take effect pursuant to clauses 7A and or 7B, nothing in this contract confers or is intended to confer any right to enforce any of its terms on any party who is not a party to it. So that's a clause that is giving purchasers, tenants and funders some rights under the contract, but that's it. Nobody else can take action under the contract. Now here are 3 slides which show you the contractual relationship between various parties to a contract. Sorry, to a construction project. Here they are, the lines link them all together, and that's all well and good. So you have the employer who clearly has a contract with the contractor, who in turn has contracts with his subcontractors, and that's all fine. But the employer, for example, does not have a direct relationship with the subcontractors, so that he has no rights of action under those contracts. Only the contractor has rights with the subcontractors and vice versa. Now, this is all well and good because, as I've said, in most of these contracts, there are burdens that are attached to it, so things you have to do. in order to make sure that you get paid. So on the one hand, you've got burdens in the contract, things you have to do, and if you don't do them, you can be sued for not doing them. But equally, once you've done them, you get paid for them. All well and good. But look at this situation. Say the employer has set up a special purpose vehicle for this particular construction project. So effectively a limited company with few or no assets. And say for whatever reason that company goes insolvent. So suddenly the employer is now insolvent. So the contractual relationships between the first purchaser, the Design 1, Design 2, QS, CAEA fund are all running into difficulty. Because how are these people going to get themselves paid? The employer's gone bust. So the whole thing, though it's lovely and neatly set out there, starts to very slowly fall apart and have difficulties. There is just another example of sometimes how contracting parties can allow others to have rights under their contract, and there's another one as well. But the fundamental purpose of these diagrams is to explain that there are direct contractual rights. There are sometimes indirect contractual rights, so some parties do have some rights under the terms of a contract that they are not a party to, which I think you can all see the difficulty if one of these parties suddenly becomes insolvent, which regrettably happened a reasonable amount of time before COVID-19, but I have a sneaking suspicion it's going to happen a lot more now that we gradually come out of lockdown. So let's have a look at design liabilities. Just bear with me 1 second. Apologies. JCT, Standard Building Contract 2016, Intermediate Contract with Design 2016, and Minor Works with Design 2016 are not design and build contracts. They are only suitable when the contractor is to be responsible for a discrete element of the design. So a tiny bit, not the full shebang, but some very tiny design element. JCT, SBC, ICD and MWD 2016. In completing the design for works, the contractor is not required to take responsibility either for the contents of the employer's requirements or for verifying the accuracy of any design contained in the employer's requirements. JCT SBC clause 2.13. That's important for everyone to know. JCT SBC ICD and MWD 2016. That above provision, the one I just referred to on the previous slide, appears to have been intended to counter the possible implications of a 2002 case between the Cooperative Insurance Society Limited and Hmrc Scotland Limited, where it was held that a contractor required to complete design work was under a duty of care to examine an employer's pre-existing design and to satisfy himself that this was such that would produce a completed design that could be built. The previous slide seems to have been brought in to overrule that Hmrc Scotland case. However, under the JCT, under SBC 2016, DB 2016 and ITC 2016, but not MWD 2016, the contractor is obliged to notify any inadequacies in the employer's requirements on becoming aware of them and to seek reimbursement by way of a variation to the contract. So you realise that something's not right, He's got to put it right, but he says to the employer, look, I'm going to put this right, but we're going to have to vary the contract because for me to put it right, it's going to cost X amount of money. Plus, it is incumbent on the contractor to ensure the employer's design complies with any statutory requirements, except in DB 2016, where the ER state they are so compliant. So again, the contractor finds out that the employer's design does not comply with a relevant statutory requirement, can't complete the build without it doing so, he incurs additional costs, he applies to vary the contract. Now, under the JCT, it is open to the employers to delete, amend the above provision, and this is also a common amendment that employers make. Employers will commonly seek to make a chain of amendments to the recitals and to the above provisions to reverse the allocation of risk, namely to make the contractor responsible entirely for the design contained in the employer's requirements. This is very common, it's often done, and care needs to be taken when entering into contracts if the employer wishes to make these amendments. This will make the contractor, he is required to undertake any design work to the standard expected of an appropriate professional consultant, such as an architect or consulting engineer, appointed directly by the employer and not undertaking any construction work. JTT SBC 2016 contractor's design documents. These are defined in the contract as the drawings, details and specifications of materials, goods and workmanship and other related documents prepared by or for the contractor in relation to the contractor's design portion. The contractor's design submission procedure is set out in Schedule 1. It sets out a submission, approval and communication system in relation to the contractor's design documents. This procedure and the employer's involvement in it does not affect the contractor's liability for design. So it's not going to be a defense to say, well, you, the employer, you knew all about this. No, doesn't work. The contractor is still liable for the design. Excuse me. Standard form contracts, key provisions and mechanisms. Let's have a quick look at these. We need to look at how the courts will look at, or indeed how an adjudicator will look at interpreting provisions of the contract. The general principle is that common law, a contract will generally be construed as a whole, i.e. all the conditions and all the documents and all the schedules will all be read together when the court or the adjudicator comes to interpret a contract. But no matter how carefully a contract is drafted, there is always going to be some ambiguity. And it's the court's or the adjudicator's job, with the use of common law and case law, they have developed certain principles which they apply as an aid to interpretation of a contract. So, there is a rule of construction that greater weight should be given to conditions that have been specifically drafted against those which are of a standard nature. That's quite correct. So if you have a standard JCT form contract, then that's fine, no problems with that. But if you have made specific amendments to it, then the court gives those greater weight, because the court's primary concern at all times is to make sure the contract complies with the intention of the parties at the time that they contracted. And if they put a specific clause in there, then the courts will give that additional weight. Now, Of course, that rule is fairly well known to those that draft contracts on a regular basis, and very often in the contract itself, that rule of construction will be excluded, and there will be a clause that says all of the terms of this contract are to be read together, and no one clause should be given any more weight than any other. The general rule then, when it comes to looking at documents, well, handwritten goes over typewritten, which goes over a standard printed document. But the hierarchy of documents, including common amendments to the standard form. So if you have a standard form document, that's fine, that will be read, no problem at all. But if you have made handwritten amendments to it, so both parties have sat down, both made handwritten amendments to a contract, both then signed it, that will be normally given precedence. However, and here's a little plea from all construction lawyers of all firms everywhere, if you are going to make handwritten amendments to JCT contracts, please, please, please make sure that I can actually read them. It's always good if you can read people's handwriting, and the number of times that we have seen amendments to JCT contracts with frankly illegible handwriting will probably mean that if the court can't read it, it will be ignored anyway. And of course, the best way to do it is to typewrite your amendments excuse me, onto a JCT contract, and then it's clear for everyone to see. Now, common problems, well, we have errors and inadequacy in the contract bills and the CPD documents that go with them. There's sometimes conflicts in and between the documents generally, and also in and between the documents relating to CPD. So things often go wrong. So you have two versions of drawing revisions, and the wrong version is signed. This is never good. What you need to make sure when you're formulating the contract and getting it into final signing form is that all these schedules, attachments, and drawings referred to are all there, so that you have one set of the complete documentation. Now, in circumstance one there, were it to go to court, it's unlikely, though it does happen, it's unlikely that that would be too much of a problem, because the parties would both accept, look, yes, this was the wrong drawing, it should have been this one, and that's fine. But if they can't agree, then there is a real problem there. The contract's drawing list does not correspond with the drawing signed. Yeah, that's fine. That's another one that causes difficulty. Again, what the construction industry is not particularly good at, and this is not in any way a criticism, because I understand the pressure to get things signed, etc., and get on with work, but they're pretty bad at making sure that we get a contract which is, first of all, signed by all parties, secondly, has all the correct appendices, drawings, etc. attached to it. Very often we will get unsigned documents, we will get documents with illegible handwriting, we'll get no drawings attached to it at all. So please, as a plea from all construction lawyers, would you please make sure that there is just one nice contract that we can all look at. It saves everyone money in the end. I don't then have to scrabble around looking at case law, etc., trying to work out, find a case that will interpret this contract appropriately. There's a failure often to complete the contractual documents, as I've just said, that half the time they're never signed. They're not dated. They've just had someone write on them and they say, well, that was our contract. Well, no, it's nice to put a date on the contract, and it's always very good to sign them. And then there's a failure to complete formalities, and that in particular relates to executing documents by deed to extend the time limit to 12 years. That's the primary reason why documents are executed by deed. But there are formalities. You can't just sign it. It has to be witnessed. It has to normally bear the company seal, etc. If you don't execute a document correctly and it's supposed to be under deed, it won't be under deed. It'll just be a standard contract, in which case you'll be stuck with the normal 6-year contract rule. The Contracts Right of Third Parties Act 1999, third parties may achieve entitlement to an enforceable benefit through either of two routes provided by Section 1.1 and Section 1.2 of the Contract Rights of Third Parties Act. Where the contract expressly states that they may enforce a term in their own right, we saw that in one of the very first slides, you might give a tenant some rights under a contract. Yeah? Or where the terms of the contract purport to confer benefits on them, provided under Section 1.2, then it cannot be construed on a proper construction that the parties to the contract did not intend the term to be enforceable by others. Rarely happens, but you can see a situation whereby that some parties may have just adopted a standard form and forgotten to take out the part that gave other people rights. Well, you're going to face some difficulties there. Section 1.3 provides that third parties may be identified by name, obviously, as a member of a class, so all subcontractors, or by description. They need not be in existence equally when the contract was entered into as well. That's unusual, but not uncommon. So you will have perhaps a contractor creating a special purpose vehicle for the purposes of this construction project alone. It doesn't exist at the time that the contract was entered into, but as long as the contractor is referred to as a contractor, then that will be fine. How do the parties enforce such a provision? Section 1.5 gives the qualifying third party the same remedies as he would be if he were a party to the contract. Broadly, the remedies under a contract are, if you do not perform your obligations, your burdens under the contract, then you can be sued for not doing so. I think that's all fairly common, and we all understand that. Equally, if you don't get paid and you having done the job you were supposed to do under the terms of the contract, then you can sue on it. And those rights are also, and the qualifying third party will also have the same rights. In terms of how he goes about it, well, he does it by way of notice between the parties to the contract that rights will be conferred upon the third party. Again, if you are going to give a third party rights under the contract, I would very strongly suggest that you limit that third party's rights so that it does not have all of the potential remedies under the contract. So you may have to, for example, join a tenant into it, but you wouldn't want to give him every last single right under the contract. You may want him to have a couple of rights, in which case specify those, set them out clearly in writing so that there is no issues for the court to interpret. Court can clearly read that you intended that tenant to have these rights and no more. Third-party rights for purchasers and tenants under JCT. These rights and limitations are set out under Schedule 5, Part 1. They include rights granted by the contractor as being works to comply with the contract and good practice. The contractor's liability. No rights to take instructions from the purchasers and tenants. Use of contractors' design documents. Professional indemnity insurance. We'll come on to that later. Assignment, giving of notices, and enforcement of rights. Okay. Now, very often there will be a funder involved in complicated construction projects, and under the JCT, these rights and indeed limitations are set out in Schedule 5, Part 1. They include rights by the contractor as being works to comply with the contract and good practice. the contractor's liability under the contract, no rights to take instructions unless he steps into the place of the employer. So the funder may sometimes, if a SPV, special purpose vehicle, goes bust, the funder might step into the shoes of the employer. Step-in rights, that's the most significant difference. So the use of contractors' design documents, professional indemnity insurance again, assignment, giving of notices, and enforcement of rights. Collateral warranties. The employer may want the contractor to grant rights to purchasers, tenants, and the funder by way of a collateral warranty under clauses 7C and 7D. Similarly, they may want for the same beneficiaries to benefit from the rights granted by subcontractors under clause 7E. The collateral warranty is no more than an obligation to enter into a separate agreement upon specified terms. This to date is the most common and tends to cause the majority of problems. So a collateral warranty is normally a separate document. While it is triggered within the contract particulars, the procurement and delivery of such agreements can lead to difficult processes. The promise given by the contractor in the warranty is given as a practical completion, so the request can be made up to and following practical completion. Excuse me. Most in the industry will understand the difficulty in procurement if the contractor or any other party does not enter into the required warranty, and clearly no benefit can be enforced. Under most standard forms, there are no sanctions in the contract for failing to comply with the employer's notice. So, what is the solution? Well, warranties. But there are a number of common problems with warranties, and we will look at some of them now. TPR versus collateral warranties. Well, enforcement, the ease of obtaining them, there's a reduction of administration and habits, including step-in rights for the funder. Now, what we can do about that is we can have bonds, which can be placed in the surety market or by a bank, but you have to be careful whether you have a bond that's conditional or on demand. Now, there are a number of types of bonds. There are bid bonds. Bid bonds guarantees performance at the tender stage. So, you've tendered for a contract, and you say you are going to do this, 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 and this will be the most fabulous construction project the world has ever known. And you can put your money where your mouth is and get a bid bond, which will guarantee your performance, i.e. what you said you will do at the tender stage. There are also performance bonds, which guarantees performance during the construction period and the defects liability period. So, you've said in the tender thing that your tender documentation you're going to do this, fine. During the actual construction progress, you get a performance bond which makes sure that you do. You can get a retention bond, which can be provided in lieu of retention. There are also things called RPA bonds. Well, they're primarily used by the food sector for food importation, etc., in case of delay on the vessel and the food goes rotten, etc. And there are Hmrc duty deferment bonds. Again, these are used by importers. Effectively, they take out a bond to guarantee that if there is any liability to Hmrc, then the bond will pay out. There is also advanced payment bonds. These are provided where goods are ordered, but payment is deferred until delivery on site. Again, you have a situation where you've ordered the goods, you don't get paid until it's delivered to the site, but during transit, for example, all of the goods are destroyed. So an advanced payment bond assists there. There's a Highways Act bond as well that works in relation to public works and section agreements. These guarantee road, sewer, street lighting will be installed to adoption standard. So when you've built your nice housing estate of 5 luxury detached properties, it will mean that if the road that you put down does not comply with to local authority standard, etc., then you can have a Highways Act bond to assist. There are also waste operator licenses, trans-frontier shipment waste bonds. As you can imagine, they are specific to the waste industry. And there are pension bonds for companies that TUPE staff who have a legacy public sector defined benefit pension. So that's the bond market. Now let's look at the surety market. Certain insurers, HCC, Aviva, QBE, RSA, Zurich, Euler Hermes, Chubb, Liberty, Hiscox, AIG, Markel and Travellers, all have a minimum Standard & Poor's rating of A and are capable of providing surety market bonds. Just one point there. The insurance market at the moment is not in a particularly good way. There has been a lack of capacity within the insurance market due to Lloyd's of London insisting that underwriters actually now charge a proper premium for underwriting a contract, and that led to a number of insurers pulling out of the market. Insurers, especially in the construction industry, are very frightened about the liabilities they will have to pay in relation to the tragic events at Grenfell. In addition, there has been the aircraft, the 737 MAX, which has caused a major market loss, and they are all petrified about what the court is going to say in mid-July in relation to their liability for COVID-19 if, as most of them put in their policies, that a notifiable disease would be covered under certain circumstances. So due to the hard insurance market, the first since 2002, and 2002 only lasted a year or so, being triggered by the tragic events of 9/11 and the worst floods in Europe for, I think, 250 years, there are now fewer insurers providing bonds, and in particular, they are much more stringent in terms of due diligence. So gone are the days where you provided really very basic details, which you may have done as little as 4 years ago. Now they are demanding much more information, and not surprisingly, with a lack of capacity, the cost has increased. It's still pretty competitive, don't get me wrong, but it has certainly gone up, and in fact is likely to go up more, especially if the insurance market is held is forced to pay claims related to COVID-19. You can also get sureties from banks. Most of the big banks will do a surety bond. However, one thing to be aware of is do not please go to the offshore market. It is a recipe for disaster. There are a number of overseas insurance companies that say they will provide bonds, and indeed a number of overseas banks that also say they will provide bonds. The chances realistically of me being able to enforce a surety if it is placed by an insurance company based in, say, I don't know, Libya, is nil. Same with Russia, nil. Croatia, nil. So don't go near offshore markets. You will not be able to enforce at all, and it will leave you considerably out of pocket. The attraction with them is that, of course, they are cheap, but they're cheap for a reason, because it's very difficult to make them pay out. In terms of market share approximate, well, insurers have about 30%, banks have about 65%, and the offshore is, unfortunately for some, still accounts for about 5%. Is that still likely to be the case now? I think so, probably. Though I'm slightly nervous about what's going to happen in the insurance market, given the issues that I've just set out for you. So what happens? Well, banks typically require 100% collateral through cash coverage, and in addition, they will raise a charge to support a bond. A surety's start point is zero collateral, so sureties accept that there may be an insolvency risk. If a bank issues you with a bond, the wordings are always, as is common with just about every bank document you ever see, is that they can have their money back on demand. So certainly during the financial crisis of 2008, 2009, the banks called in everything because they could, because they were all overdrafts, whatever, were all on demand. And that's what banks do. So try and avoid that. Sureties, with a few exceptions for certain types of bond, there are conditional bond wordings, which you need to clearly draft and probably have reviewed by a lawyer. Banks, to some extent, have retreated from sureties, but are still dominant in the UK and Ireland. I suspect at the moment, because it's, if you like, payback time for the banks, because we bailed them out in 2008-9, they will not be retreating further from this at the present time. Who knows what might happen in 2 or 3 years. Sureties normally, they'll have stronger credit ratings, and the market share is steadily increasing in the UK. In the US, sureties have 90% of the market share. And again, until the recent crisis, I would have still agreed with that statement. But as I expressed, I am concerned about what is the state of the insurance market going to be after, or if, they are asked to start paying in relation to COVID-19 losses. So, should you have your surety, etc. bonds, conditional or on demand? Well, conditional contract guarantee bonds follow the underlying contract and are triggered by a breach of the contract, including insolvency. On-demand bank guarantees do not follow the contract and can be triggered on the beneficiary's request. So certainly for performance bonds, avoid this. They should be avoided as per the Association of British Insurers and the Office of the Deputy Prime Minister. So I would always go for surety rather than anything provided by a bank. Bank documentation is always on demand, and that will cause problems. Association of British Insurers model bond forms are fair for all parties, but you can negotiate amendments to them. But a surety is, in my view, the best way to solve a number of problems. They're not on demand, they follow the contract, and whilst they might be slightly more expensive, they are a much more flexible instrument. So what will you need if you want a bond? Well, you'll need the general company information form. You'll need to fill out an application form. You have to have a bank information form, a bank facility letter, a bond wording. You will need budget and forecast accounts, including cash flow forecasts, what your current order book is and your pipeline of work. You'll need, obviously, audited reports and accounts. management accounts and supporting balance sheets, and a land and development schedule for developers. Now, that was the information before COVID-19. After COVID-19, I suspect that will have increased, whether it's a bond or a surety. Much more information is going to now be demanded before anyone is going to issue a bond or a surety. Now, you might say, John, what more can they ask? Well, the answer is probably a great deal. They'll start looking into directors' personal wealth. They'll start looking into the effects that COVID-19 have had on the business, etc. So it will be more complicated from now on. So that, in conclusion, ladies and gentlemen, was all that I had to say. In terms of the last section, I would very much encourage you to go for surety rather than bonds, simply because really anything to do with banks, because of their drafting of on-demand documentation, should really be avoided at all costs. Julie, that was all I was going to say.
Okay.
Oh,
We
you
do
are
have
awake still, that's good.
I am awake, always awake when you're talking, John. It's so interesting.
Oh, thank you.
Right, we have had one question in from someone who's had a clause added to 6.15.3 on terms that do not require the contractor to discharge any liability before being entitled to recover from the insurers, and that would not adversely affect the rights of any person to recover from the insurers under the Third Parties Rights Against Insurers Act 2010. And he says, what does this mean?
Yes, that's a good one. Difficult to answer that question quickly. The main effect of the Third Parties Rights Against Insurers Act was, well, yeah, it's very difficult to know exactly what that means. If you're asking me now, it seems that that clause is contradicting itself. I think it's very poorly drafted. But Julie, to be fair, it may be better if the person emailed me that question.
Yeah,
and
no
I
problem.
will look at that, because it's just when you read it out there, it doesn't seem to make, frankly, any sense at all to me. I'm not quite sure what it would mean. I can have a stab at it, but I really don't think me, with respect to everybody else listening, trying to understand it and interpret it now is going to really help, because frankly, I don't think it makes any sense. It's an attempt at something, but I'm not quite sure what.
Right, okay.
So sorry I can't be more helpful on that. I accept that that's probably about as useful as an ice cream in a sauna, but not much I can do about that, I'm afraid.
No problem. I will. I'll ask the person concerned, and we'll get that sorted for them directly. Okay. Well, that appears to be the only question. So obviously you've explained everything else so brilliantly that everyone understood it, which is fantastic.
I very much doubt that, Julie, but I've done my best.
So thank you very much to all of you for attending this morning, and have a good day at work, whether that's at home or on site or whoever's back. John, thank you as always for sharing your expertise with us, and we will see you all again soon. Thank you and stay safe.
Thank you, everyone.